This powerful courtroom video begins with a tense and emotional sentencing hearing that immediately highlights the serious consequences of domestic violence. Garland Green appears before Judge Stephanie Boyd after pleading guilty to assaulting his wife, but what makes the situation even more troubling is that their 4-year-old daughter witnessed the entire incident. From the very start, the atmosphere is heavy, as the court carefully examines not just the crime itself, but the deeper impact it has had on the family, especially the child. As the hearing unfolds, it becomes clear that this is more than just a routine legal proceeding. The judge takes a firm and uncompromising stance, making it evident that accountability and long-term change are the top priorities. The discussion quickly shifts beyond legal technicalities, focusing on the emotional and psychological damage caused by violence in the home. There is a strong emphasis on how such incidents can shape a child's understanding of relationships, potentially normalizing harmful behavior if not addressed properly. This introduction sets the stage for a deeply impactful hearing, where the court not only delivers a sentence but also sends a clear message about responsibility, consequences, and the importance of breaking cycles of abuse for the sake of future generations.
With your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Green, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on the lesser included charge of assault, bodily injury, married cohabitation.
Any objection?
No objection from defense, Your Honor.
All right, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married, or cohabitation as a Class A misdemeanor?
Yes.
The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your
Do you
Honor.
believe he's currently competent and was legally sane at the time of the offense?
I believe that he is and he was, Your Honor.
Mr. Green, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with the affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge, there have not.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 2 years. There be no contact with Jesse Willard, Jessie, WHEELER, the BIPP program, and anger management. Did you understand those were conditions that the state is recommending and the court does not have to follow that? Then to the lesser included offense of assault, bodily injury, marriage, cohabitation. How do you plead? Guilty, not guilty, or no contest? State any evidence?
The state offers State's Exhibit 1 in all of its attachments.
Defense is reviewed, Judge. We have no objection.
And state, have you talked to the complainant?
We have previously, Your Honor, in complete candor, the complaining witness has signed an affidavit of non-prosecution and was uncooperative with our case.
All right, thank you. You may be excused.
Thank you, Your Honor.
All right, Mr. Green, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements or police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. In regard to the no contact order with Jesse Wheeler, the parties are cohabitating. They do share a 5-year-old son who just started school yesterday. My client works at Pepsi during the day. Mother works for Rackspace at night. So the no contact order would impose an unduly burden on the parties in respect to parenting this child. As is usually the case, Your Honor, in these situations, CPS was involved as per family-based service plan. The parties went to counseling. My client went to counseling and is continuing to go to counseling. Both parties have been and are attending marriage counseling at this time. My client says that it's been a good influence on both them and their relationship. And they feel that the no contact order, if implemented, as mentioned, would be a burden not only on their relationship, on their status, but their ability to parent the 5-year-old child.
Oh, I'm sorry. My dad, he doesn't really help. And my mom, she can't because she physically can't move around to help watch my 5-year-old.
All right, so here's the thing. I'm not going to do a no harmful or injurious contact. If there wants to be a no contact order, then the complainant can appear by Zoom or even in person. I want you to understand something.
Yes, ma'am.
I read the police report, and in the police report, you said she was pushing your buttons, you're pushing her buttons, and you can unfold your arms, and all of you all were acting not as adults. Y'all were acting like children. And the child at the time was 4 years old. You all caused drama and trauma to a 4-year-old. What is a 4-year-old supposed to think? And you and the complainant are going through the apartment throwing things around. And you tell a 4-year-old, don't throw that, place it back where it's supposed to be, and trying to lay down the law to a 4-year-old, and you all are acting worse than the 4-year-old.
Yes, ma'am.
And that's a memory that 4-year-old is going to have forever. No amount of counseling that you all go to try to put your life together is going to take away that the 4-year-old witnessed all of this drama in their life. So if he wants to have contact with the mom and they're working things out, she needs to appear by Zoom and the court will consider it. If you want to get her to Zoom in here today, then I'll consider it today. Is she able to Zoom today?
She's asleep because she works at night.
Oh, well, if somebody wants to call her and have her Zoom in.
I can call her.
All right. So it's going to be 2 years deferred adjudication, affirmative finding of family violence, no contact with Jesse Wheeler. Of course, if you call her and she Zooms in today, I'll reconsider.
Okay.
The BIPP course, 80 hours community service restitution. I'm going to order parenting classes. If you've done parenting classes through CPS, that will be acceptable. If you have not, then you'll need to do parenting classes. If he's completed parenting classes related to this incident through CPS, then the community service hours will be deemed to be satisfied. There's to be anger management. There's to be CPS compliance. It sounds like it's a safety plan. So whatever the safety plan is giving them, just make sure he's doing that. And probation, if what he's doing for his CPS safety plans coincides with what I'm requesting, then the CPS, what they're doing will be enough. There's going to be regular reporting by Zoom or in person, regular UAs, and field visits one time. Well, field visits, I want at least 3 field visits throughout the entirety of his probation. So you only have to do 3. If you deem that there's something that's an issue, then of course you can do more, but a total of 3 field visits throughout his probation. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Probation, is there anything else you need? Jesse, Jessie, Wheeler, Wheeler. That may not stand if he's able to get her to zoom in. Is there anything else you need from the court? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
We can go off the record. Here's the thing. When there is violence in a home, children learn how to behave, right? So if somebody wins an argument by being violent, guess what? A child realizes, hey, if I want to win an argument, I need to be violent. Or here's the thing, you have a daughter. A daughter will think that you love her mom, right? You love her. So a daughter will begin to think, oh, this is how somebody who loves you shows that they love you. They're abusive. And then your daughter goes out in the world, and if she ends up with, as my professor in high school would say, and I say professor because he was a doctor who taught us physics, he would always say, girls, do not end up with a joker. So your daughter may end up with a joker. Don't let her be, you be the reason she ends up with a joker. And he would give instruction to the guys too. So you've got to do better. You understand?
I understand.
All right. Thank you.
As the hearing comes to an end, the atmosphere remains serious and reflective, leaving behind a message that goes far beyond the courtroom itself. The judge's final remarks strongly reinforce that this situation is not just about punishment, but about taking responsibility for actions that have deeply affected a family, especially a young child who witnessed something no child should ever have to see. It's made clear that the emotional impact of such moments can last for years, shaping how a child understands love, trust, and relationships. The conclusion highlights that the conditions imposed are not simply rules to follow, but a structured path toward real change. The defendant is given a chance, but it comes with high expectations to actively work on his behavior, to reflect on his actions, and to prove that he can become a safer and more responsible person. The judge's words serve as both a warning and a wake-up call, stressing that continuing down the same path could lead to far more serious consequences in the future. Ultimately, the hearing ends on a powerful and thought-provoking note. It sends a clear message that breaking the cycle of violence is not only possible, but necessary. The future, especially for the child involved, depends on the choices made from this point forward. Whether this moment becomes a turning point or just another missed opportunity is entirely in the defendant's hands, but the weight of that decision is undeniable.